Transcripts and meeting minutes will be made publicly available after this meeting and will include the names of those in attendance during today's call. If you object to this, you may disconnect at this time. This is a meeting of a federal advisory committee established by the Native American Graves Protection and Repatriation Act of 1990. And this meeting is regulated by the Federal Advisory Committee Act and its implementing regulations. This meeting was noticed in the Federal Register on June 2nd, 2021. An agenda for this meeting and a summary of each of the past meetings is posted to the NAGPRA program events page. The Act, NAGPRA, and the charter for this committee govern the objectives and scope of activities for this committee. All members of the review committee are appointed by the Secretary of the Interior and serve as special government employees. With that as an introduction, I'd like to start with a roll call of committee members. Please answer out loud. Honor Keeler.
Here.
Barnaby Lewis.
Here.
Timothy McEwen.
Here.
Frank McManaman.
Here.
Armand Menthorn.
Here.
Shelby Tisdale. Shelby is traveling and is having some trouble connecting. Hopefully she'll be able to join us soon. John Beaver. John informed me that due to a family emergency, he would not be able to join us today. I would also like to acknowledge the individuals who are assisting me today in conducting this meeting. With me are attorneys from the Department of the Interior, Office of the Solicitor, Brady Blasco, Division of Parks and Wildlife, and Stephen Simpson, Division of Indian Affairs. From the National NAGPRA program, Lisa Koszalski is the review committee coordinator responsible for organizing this meeting and preparing the minutes and transcripts of these proceedings. At this meeting and at the next two meetings, August 10th and August 19th, there is time allotted for presentations by museums, federal agencies, Indian tribes, and Native Hawaiian organizations on the implementation of repatriation activities under NAGPRA. Anyone who is interested in making a presentation should contact me with your request at NAGPRA_info at NPS, that's National Park Service, nps.gov. At this time, we have no requests for presentations. There is also time allotted for additional disposition requests on August 10th and August 19th. Material for those requests must be submitted to me at least 20 days prior to the meeting. At this time, we have no requests for disposition pending. Every meeting of the review committee includes time for public comment as required under FACA. Within the scope of NAGPRA, the review committee is very interested in receiving public comments on the progress made and any barriers encountered in implementing repatriation activities under NAGPRA. If you're interested in providing a public comment during this meeting or at future meetings, please let me know. Later today, I will turn on the chat feature for this meeting, or you can raise your hand to request to make a public comment. You can also email me to make your request. At this time, I would like to go ahead and call the meeting to order. Although we are missing two members of the committee, I believe that we can proceed with our topics for discussion today. We may want to revisit any decisions or actions the committee might want to take today. We might hold off on those until there is a full committee, hopefully at the next meeting, but we should be able to proceed with our discussion and the agenda that we have before us today. Mr. Chair, before we begin with that agenda, would you like to provide an opportunity for an invocation or a traditional welcome?
Thank you, Melanie.
Again, as we come together, we ask our Creator today to listen to our hearts and our mind and whatever need or needs that we have. We ask our Creator today to watch over our friends and our family. During this time, as the virus continues to spread, we ask Creator, give us strength to help one another. We ask Creator today that Mother Nature can hear us, our prayers, as these fires are all around us here in the Northwest. We ask Creator today to guide us with our thoughts and our words. We ask Creator today to make it strong, the direction that we're going with each other. Thank you.
Thank you. The first item on the agenda for today is a report from the National NAGPRA program on NAGPRA grants. During a recent subcommittee meeting, the subcommittee on the annual report to Congress, the subcommittee requested some specific information from the NAGPRA program on NAGPRA grants. Sarah Glass, the Notice and Grants Coordinator for the National NAGPRA program, prepared a report for you today. The report was posted to the meeting materials on the NAGPRA events page and also sent directly to the members of the review committee. Sarah wrote a very excellent and thorough report. I am not going to read the entire thing to you, but I would like to provide you with just a summary of the information that she provided. First of all, Sarah apologizes for not being able to make this presentation today, but she is happy to answer any follow-up questions that you might have. In her presentation, she touches on 4 topics. She provides sample language from the National Historic Preservation Act regarding the limitations of administrative costs for certain grants. She provides a summary of indirect costs as applied to NAGPRA grants in 2 fiscal years, 2019 and 2020. She provides an overview of the grant program's successes and challenges during fiscal year 2020. And finally, she provides a broad statement on the overall effectiveness of NAGPRA grants. Again, there is more detail in Sarah's report. Hopefully it provides the specific information that the subcommittee requested from Sarah. We can discuss some of the content of her report if the committee wishes to, or if you have questions based on her report, we can have a discussion, or we can simply move ahead and the subcommittee can consider this information.
Yes, Jim.
I very briefly looked over the grant, what Sarah put together. It was very thorough. I really thank her for that. The one thing that I didn't see that I think would be useful to us, particularly on doing the report to Congress, and my apologies if it's there and I just missed it, is that it would be useful to know for each year, FY19, FY20, FY21, the number of applications received, the total amount requested for each year, the number of grants awarded, and the total monetary amount awarded. And that would give us some good, I think, statistics to sort of come up with our specific language for our report.
That information is contained in the program's annual report. And you should be able to find it for 19 and 20 in the beginning of the program's report. The information for 21 is not yet available.
I guess I looked at the 19 and 20 report and I couldn't find it. So it might be useful, it probably wouldn't be onerous to sort of put it in a little chart that we could use. I'd
Sure.
appreciate it. Thank you.
Can do that.
This is Frank. I also want to thank Sarah and Melanie for assembling this report. I think it is useful, and I'm glad to hear Tim's comment. I think it will be useful for drafting the 2021 report, which is what the subcommittee is currently working on.
This is Barnaby. I don't have any questions or comments.
Honor, did you have anything?
Not at the moment, Armand, but may come back to me in a minute.
Hey, Melanie, moving on.
Certainly. The next item on the agenda for today is presentations. Again, I have not received any requests for presentations to the review committee. If there is anyone who would like to request to make a presentation, you may do so by emailing me at nagpra_info@nps.gov, and we will schedule a time for you to make a presentation at the next meeting on August 10th. As there are no presentations, we can proceed then to the next item on the agenda, which is the review committee's discussion of the draft regulations, in particular subparts A and D. I have developed and provided to the committee several things, some of them just within the last few hours. All of the information that has been provided is also available in the meeting materials. A minute, I think I did that wrong. Try again. Oh. No, that is what I meant to do. Can you see the presentation?
Yes.
I can see it on, it's a shared screen.
Yes. Okay. Okay, so I provided the a copy of the presentation to the committee, and there is a copy also available on in the meeting materials. To assist the committee in a discussion of the draft regulations and in developing its recommendations on the draft, I'd like to provide first a brief overview of the regulations. So 43 CFR Part 10, the purpose of these regulations is to provide a systematic process to determine the rights to Native American human remains and other cultural items under NAGPRA. As most of you know, the history of regulations for NAGPRA is identified here. Regulations have been published as final in 1995, 2003, 2007, 2010, and 2015. Furthermore, from 2010 to 2012, the Department of the Interior conducted consultation, listening sessions, and solicited written comments on revisions to the regulations. The department has received regular and repeated requests for full revisions to the regulations, most often in the course of public comments or presentations before the review committee. Here is an overview of some of the revisions that have been requested. A simplification of some of the burdensome and complicated requirements, clear timelines, a strengthening of tribal consultation, removing the use of the term culturally unidentifiable, requiring all funerary objects be returned with human remains, whether culturally affiliated or not, requiring museums to report on federal holdings, and some simplification of the procedures on federal and tribal lands. In response to this, as I outlined for you last week, and as was published in a press release on July 15th, the goal of the draft regulations is to simplify the regulatory process, rectify provisions in the current regulations that are inhibiting repatriation, remove burdens on Native Hawaiian organizations and Indian tribes, and require museums and federal agencies to complete the regulatory process within a certain time frame. There's a link here to that press release. So as an overview of the table of contents of the draft regulations, it's broken up into 4 subparts. As we discussed last week, today we will go over Subpart A and Subpart D. We will follow that on August 10th by reviewing Subpart C, museum and federal agency holdings or collections. And then on August 19th, look at federal and tribal lands. Again, this information largely comes from a document that was posted to the NAGPRA program website called an overview of changes. That document has been available on our regulations page. Anyone who's interested in reviewing that document, you can find it there. It lays out as best we can a comparison between the current regulation text and the draft text. So again, in looking at a comparison of the draft sections to the current sections, we will be going over this material more in depth today. Again, what I've prepared today is a bit of a higher level overview, along with some comparisons between the draft text and the current text to help facilitate your discussion. So with that, I'd like to proceed with a discussion of each section, and following a presentation of some information about the draft text and a comparison to the current text, I would like to start conversations then among the review committee. Does that sound acceptable to everyone?
Committee?
This is Frank. Melanie, I wonder if you wouldn't mind, if you can, to provide us with a fuller description of how the redrafting, well, how the drafting of the new draft proposed regulations was actually accomplished. The only explanation other than what you just told us, and I think you've sort of told us this in a few earlier meetings that I've been involved in where this came up, is that document that you distributed several months ago, I think, about the 2011 consultation meeting with tribes. You did, in very few words just now, explain that there have been lots of presentations at meetings by different groups. We don't have a list of those groups, or we haven't seen copies of what those comments were that were taken into account. And you noted other kinds of means, but there's no sort of summary of what they were, what issues were discussed. One thing in particular that I'm interested in is what you've heard from the museum and scientific communities, for example, about this. We've seen what at least that one consultation meeting with tribes resulted in terms of more specific set of guidance for amount of time that lapses between different requests and different responses and that sort of thing. But what's your understanding, at least since you weren't there the whole time in the program, that this happened? Who did it? Who drafted it? When was it drafted? What were the different stages of drafting? Can you fill us in a little bit more on that?
I certainly can, and when the proposed rule is published in the Federal Register, it will contain obviously a full preamble that will go into more detail on the drafting and including a summary of comments that were received during those initial consultations and written comments in 2010 through 2012.
Well, just to follow up on that a little bit, my understanding is that a preamble is published when an agency publishes a final version in the Federal Register, and that, in fact, goes through item by item by item, as Tim very well knows, in response to all the comments that came in as part of the Federal Review notice. But I was not aware, and I may be wrong, I was not aware that that same kind of very detailed description of a proposed regulation was part of the initial public publication in the Federal Register for public review and comment.
Well, any proposed rule generally contains information on how the rule was drafted. In this case, because these are revisions to an existing regulation, and because the department solicited specific comments and consultation on revisions to the regulation, it will include an overview, not the in-depth comment and response of a final rule preamble, but it will include a summary of comments and consultation in 2010 through 2012, and then presumably it will include then as well the consultation with Indian tribes and Native Hawaiian organizations that the department is currently undertaking.
Well, you just gave us a summary, but you're saying that you expect there will be a more detailed description of that. Can you say were museum and scientific organizations asked to provide comments at some point during the nearly decade between the last formal regulation that part of the regulations that went public and now?
Yes, in fact, we have records of many comments from museums and scientific organizations, as well as from museums themselves, on issues with the current regulations. Those came in written form as well as through public meetings that were held.
Thank you.
Tim?
My understanding is that this draft, what is now a draft, was initially scheduled to be published as a proposed rule some time ago, and that it's only more recently that the idea of doing the tribal consultation and the review committee consultation on the draft text has sort of come to fruition. I guess my question is, if this was ready to go some time ago, is there a draft of the preamble that would have gone in with that proposed rule in existence now?
As you note, the proposed rule, publication of a proposed rule has been in the works for a very long time and has been on the regulatory agenda. So there have been a number of drafts of both the text and the preamble for this proposed regulation that have been prepared. As I discussed to this review committee in August of 2019, we were anticipating publication of a proposed rule at some point in 2019 before the end of that calendar year. So there was a text at that time that was a full text that was being reviewed by the Department of the Interior. However, that text was never approved to be published or made public. So those are still drafts, but are not public documents.
But before us right now, we have a draft of a proposed rule that we're reviewing. I guess my question is sort of following up on Frank's comment. Can we request a copy of the draft preamble so that we can put it in a little better context? I think that would be useful for us.
I can certainly make that request on your behalf, but at this time, the department chose only to make the draft text public for consultation. They have not approved a preamble text to be distributed.
Yeah, I guess I'm not asking for the preamble. I would only like to see the most recent draft that sort of goes with the rule as it stands, the draft rule as it stands now. I think that would be useful for us.
Well, I can make that request of the department, but that may not happen. I think the intent in releasing this draft text was to facilitate consultation with Indian tribes and Native Hawaiian organizations. And based on that input, the department anticipates, or actually I should say the department will make changes to the draft text based on that consultation and input from Indian tribes and Native Hawaiian organizations.
Generally, when the department consults with Indian tribes on draft regulations, what it provides to the tribes is the draft text of the regulation and the sort of background information that Melanie has provided to the tribes and the NHOs and the committee. There is sometimes a preamble drafted at that point, but as Melanie points out, that is not a public document, and so it is generally not provided to anyone. But we can, as Melanie points out, we can check.
This is Frank again. I realized that you've been careful to characterize the discussions with the tribal groups that are coming up as consultation under the the government to government process and procedures. I think part of our discussion here is, and this is a continuation of the discussions that we, I guess, started in October of 2019 that Melanie referred to, is the review committee's responsibilities and an opportunity, providing an opportunity to assist the secretary with regulations, with developing regulations. And I agree with Tim. I think, which is why I asked the question in the first place, what's the context for the changes? What were the, we have some sense, although only from one meeting, of what some of the tribal concerns were with timing and things of that sort. What were the concerns that were expressed by the museum and scientific organizations, and did they offer or suggest any changes that they thought would improve the implementation of the law and meeting the goals and objectives of implementing it? So I think that's still a matter that maybe other members of the committee share with me as well, but I don't think we've got that in what we've currently had to look at, although I do appreciate it. And obviously there have been a great many changes in this new version. There are new terms used. The process has been honed somewhat with specific information. So there's quite a lot of changes. The document that you mentioned, Melanie, the one that you shared recently, since the last meeting we had earlier in July, that lines up the different sections of the current regulations with this draft that we have in front of us, is helpful, but it does not explain the differences between the two. It simply says this section or this topic is no longer in subpart A. It's now in subpart B or C or wherever it happens to be, and that is a helpful general guideline to sort of see that different things are being covered, but it doesn't give any details on what those changes are, how significant they are, whether it's changing a few words or whether it's actually inserting new concepts or new texts and things like that. So there's still, it seems to me, quite a bit of work that needs to be done by the committee, I guess, in terms of coming up with a sense of how these changes affect how the law is implemented.
And I think I recall, I think John asked if there was a red line markup, and having looked at the rule, I realized that is a hard thing to do because so many things have moved around that it would just be lots of overstrikes and lots of new text. It's hard to correlate. But I think it would be useful to get sort of a matchup, not red line markup per se, but a matchup of what a particular section, regardless of where it is, happens to say about the definition of cultural affiliation, and then parallel to that, what the new one says, with between those two, what the changes are. So obviously it's not something that you can just automatically do. I'm sure it would take some time to do, but I think that would be really useful for us to get a firm idea of what's going, what the changes are, and just then evaluate what the effect might be. Because the bottom line is, if to the extent that this is to simplify a complicated process, to make things clearer, obviously those are all good things. But I think we need to sort of see it in order to evaluate whether that's what it does. And we've got, many years of experience working on NAGPRA, working, represented on this committee. So I'm sure looking at those kinds of changes, various specific instances are going to come to each of our minds that will be able to sort of gauge against those changes to see what the effect might be.
Hi, this is Honor. I'm in agreement. I also think that it might be helpful in the sections that have been changed. It seems like there have been drastic changes made in the regulations, that there be some kind of annotation and explanation of why that has been changed. I know you've touched upon this a little bit in some of the material you've created for the review committee discussion, but I see that there are a number of changes here in the regulations, and I think that might be helpful. It also might help to touch upon some of the prior public comments that were made as well.
Thank you. I will make the request to the department regarding the preamble or other comments that have been made with regard to the regulations. I did, well, I appreciate that you understand that there's no utility in a red line version, given the number of moves and changes between sections. I hope that at least the overview of changes assists with making that comparison side by side between the draft and the current text. In addition, I've prepared in these slides a couple of instances where I have put the existing text and the draft text next to each other to assist you again with that effort of seeing these changes. I can certainly, we could work on that for the entire text of the regs. That would take some time. It certainly would be an effort. And I'm not sure that it would yield the information that's needed now for the committee to undertake these broad discussions about, in general, the different parts of the regulation, and where the committee sees either issues in the current text and whether or not those issues have been addressed by the draft text. So my hope here was that this discussion, we could highlight some of those instances where there have been changes made, and the committee could then discuss whether those changes reflect issues that the committee agrees are problematic in the current text, and whether the draft text effectively solves those issues. Again, the attempt here is to come up with some very broad recommendations from the committee, much like was done with the culturally unidentifiable process, where the committee can provide, rather than specific textual edits or changes, some broad recommendations to the department about the different sections of the law and how they are working and how they might be able to work better. So we could proceed with the 4 sections that I have prepared for you today. I can work on similar documents to prepare for you for your next meetings, or we could, I guess I would like some input from you on what I've prepared today, and whether it is suitable for you to have a high-level discussion about these changes. Before we move on into the specific sections of the text, I'd like to see if we can get Shelby to unmute her phone line. I can see you, Shelby. I can't, unfortunately, make you a presenter in the meeting. I'm not quite sure why. Shelby, you should be able to unmute your line. I think it's *6. Okay. I don't think that Shelby is able to unmute her phone line. Lisa is in touch with Shelby by text, and perhaps we can find another solution as we continue. There will be an opportunity at the end of the meeting for public comment. So if anyone has raised their hand or would like to make a public comment, we will get to that later in the meeting, unless the committee would like to proceed in a different manner. My plan was to work through these sections of the proposed rule, have time for committee discussion about each of these sections, and then move on to public comment when we are finished. Does that sound like a way forward?
Melanie, this is Armin.
Yes.
Committee, as a reminder, when we had our last meeting and the meeting prior, that's when the discussion formed what we want to do today. And it was agreed on that we would proceed in this manner of what Melanie has outlined already. And we need to stick with that, so that the section by section, as outlined and agreed upon by the committee in at least 2 prior meetings, we need to stick to that and move forward with this discussion. So thank you, committee.
Thank you. So to begin with, section 1, in the draft, this is called introduction. In the current text, it is 10.1 is purpose, applicability, and information collection. Again, this information presented on the screen is taken from the overview of changes document that is available on the NAGPRA regulations page, so anyone can access that information. I have added here to help you understand some of the references to the current text. Rather than having to look up the citation, I've just provided it for you. So again, in the draft, what is currently at 10.1B2 is removed. 10.1B2 is an often questioned paragraph of the regulations. This paragraph identifies a requirement that cultural items, human remains, funerary objects, sacred objects, and objects of cultural patrimony are themselves indigenous to Alaska, Hawaii, and the continental United States. This is a paragraph that we often have questions from museums about, and in the draft, it has been removed. In addition, the draft includes 2 new paragraphs, one on a duty of care prior to repatriation. There is currently only one reference to a duty to care for cultural items in NAGPRA in the regulations, and that's in 10.7 paragraph B, with what a federal agency must do regarding unclaimed cultural items. What the draft does is take that same statement but also include a requirement for museums to exercise a duty of care prior to repatriation. And then there are 2 additional paragraphs in the draft text that include standard instructions for delivery of written documents, as well as timelines and deadlines within the rule, to be sure that it's clear what those instructions are for documents and timelines. In addition,
Excuse me, just
yes.
checking. This is Frank. If we had questions, you want to do this section by section after you finish, or how do you want to handle it?
I think if that's okay, for
That's
this
fine.
one at least, there's just 2 slides on an overview.
That's fine. I just didn't know.
Sure, thank you. The draft text also includes in 10.1 the introduction material that is currently in 10.15 and 10.17 of the regulations, and those are information on limitations and remedies, as well as dispute resolution that is moved to the introduction 10.1 section, along with some clarification on both a failure to claim or request prior to disposition or repatriation, as well as a clarification on what constitutes final agency action under the regulations, and a clarification of the judicial jurisdiction that applies to the entire regulations. Again, this is general information that is currently at the end of the regulations and has been moved to the first section of the regulations as it applies then to the entire regulations. Lastly, there is a repetition of statutory language in 10.15 currently that has been removed. So what I would suggest here is that we do start a discussion of section 10.1 in its draft form or in its current form. And I will be happy to take notes as you have your discussion to help you either today or at a later date develop recommendations.
Melanie, thanks for your overview. I appreciate that. For me, I think going through the new regulations line by line is probably the best way that I can help facilitate some conversation around this. I realize that there's been a lot of changes, but maybe you can put the draft regulations on one side of your screen and the current regulations on the other, and take notes as well, so that we can see the changes as we're going through it.
I can do that. It becomes a little challenging when we get to parts that are in different places that have been consolidated. I think I will need to try to open a couple of things in order to do that.
Should we perhaps take a a short break to allow Melanie to sort of get the technology straightened out. And did we get Shelby?
Shelby is unable to unmute for some reason. And here I have the two documents pulled up for you.
Melanie,
Yes, sir.
what's the status of Mr. Beaver?
He was unable to attend today's meeting due to a family emergency.
Okay, thank you.
Okay, so on the left side of the screen, I think it's on your left, is the draft rule text, and on the right side is the current rule text.
That's very helpful. Thank you, Melanie.
So this is Frank. Are we now sort of asking questions about the new text or changes from the old text?
Sure, yes. This is a time for the committee to discuss 10.1 introduction.
Okay. Mr. Chair, I have a comment or a question if you'd like me to proceed.
Yes.
Okay, thank you. So 10.1C, duty of care. I do think it's important that agencies and museums that hold items that may fit under the definitions of NAGPRA items is important. So I think the intent is a good one here, but the 36 CFR 79 regulations, of course, were set up for archaeological collections, and not all NAGPRA items actually fit into archaeological collections. A great many, particularly sacred objects and objects of cultural patrimony, may fall under more of an ethnographic collection. So I was a little confused even in reading it as to what the intent was here. For example, the term cultural items, which is used in this subsection, doesn't exist in 36 CFR 79. That I don't believe that term is in there. And if one of the attorneys here who's maybe familiar with that reg have different information about that, I'd be glad to be corrected by it. But it's a little confusing to manage cultural items in a custody or under control consistent with the regulations of 36 CFR 79. Again, 36 CFR 79 is set up for care and actually proper uses of these federal archaeological collections. So it's the federal connection that is part of the statutory foundation of those regulations and the laws that they derive from. So the museums, in particular, may have items that don't fit, that aren't in a federal archaeological collection. So it's a little bit, in my sense, even initially looking at it, I wasn't quite sure what the intent was here.
Thanks. Actually, Frank, I have an answer for you. And this is, again, the language here on the federal agency duty to care is in the current regulations at 10.7 B. And in the final rule for 10.7, published in 2015, there was exactly a similar, several comments on the use of the language from 36 CFR Part 79, or the reference to it in 10.7. And in response to those comments, the department stated that the final rule at 10.7, and that would again extend to the language here, requires federal agencies to care for and manage cultural items under NAGPRA in a manner consistent with, but not pursuant to, 36 CFR Part 79. That, again, it continues, even unclaimed cultural items that do not fit the definitions of 36 CFR Part 79 must be provided with the same level of care and management as those items that are covered by 36 CFR Part 79. So in 2015, that was the department's explanation for this language by using the term consistent with, not pursuant to. So it is a way of pulling in those that requirement for care, but not necessarily all of the implications of 36 CFR Part 79.
Thank you for that. I did not realize that change had been made. I'm pretty sure there were changes made in the 79 regs to take NAGPRA into account, but I didn't realize it had gone the other way as well. I still have a question about museums. It seems to me that does this add an additional requirement on museums that isn't in the statute, NAGPRA? That was something I know we had to be very careful about in drafting the original regulations.
There's no requirement in the Act or the current regulations on a duty to care for items prior to repatriation.
I understand that, and that's what I guess that's the point, is that if it isn't in the statute, can the requirement be made by writing it into a regulation? We were always cautioned that the statute leads, and if it's not in the statute, you can't automatically put something into the regulation that isn't a requirement. Not that it shouldn't be, or not that there might not be another way to do it. I just, this is my
Sure.
first reading of the text, and I have these questions.
Again, the law does state that the secretary can promulgate regulations to carry out the act, and that provides some flexibility for the secretary to determine how the law should be carried out in these regulations. And Brady has come to my rescue.
I wouldn't say rescue, but Frank, I can respond at least partially to your question, which is true that in general, we're not drafting, departments and agencies are not drafting regulations that would go beyond the scope of the requirements that sit within the Act. Now, that said, particularly in the case of NAGPRA, the Secretary has discretion to interpret how compliance with the requirements can be interpreted. And this is one of the areas where there's not as much as a new requirement, so much as trying to define what's necessary to achieve the disposition or the repatriation goals under NAGPRA, for museums, the repatriation goals, so that these cultural items can be returned respectfully and in line with that ultimate end. So it's more about helping define the how than creating a new what, if that's a helpful analogy.
Yes. So this is sort of fits in that grayish area, perhaps, that if we could look at it that way. So so the other thought that I had in reading this and thinking about 36 CFR 79 is that part of the care and management of federal archaeological collections that 36 CFR 79 was created and promulgated to facilitate includes appropriate religious, educational, and scientific uses of those collections. So consistent with the regulations at 36 CFR 79, I've got a question then. Can a museum or an agency then deny a request for that is otherwise legitimate, but that would apply, would include or focus even on NAGPRA type items that were in either the museum or the agency collection. And we've had examples of that where the museum has decided not to allow for that in their collections as part of their own policies. And I think there have been examples of maybe examples of agencies as well. But that was just another thought that I had, where using 36 CFR 79 this way might not be, while it could be easy because that exists, and there is a good set, there are a good set of care kinds of regulation or kinds of activities, functions that are carried out there. But I wouldn't want 36 CFR 79 to become a problem for anybody in terms of what it already covers and allows for by incorporating it into this set of regulations.
Well, just to clarify, the first sentence only applies to federal agencies. The second sentence is what applies to museums and duty of care.
I do understand that, and that was sort of the nature of my first question that Brady helped out on in terms of adding a responsibility to museums that they might not otherwise have. I understood they had based upon regulations and not based upon the statute.
Melanie, something that might be helpful for the public to see as well is by pulling up 36 CFR 79, as well as the rest of the review committee members. As Frank's talking.
I'm 36 CFR 79 is I think that I think we are getting away from a discussion of the broader section 10.1 as introduction. I think that you've outlined some concerns with the duty of care paragraph. I think that's worth noting and seeing if the committee can come to some recommendation to the department on how to better clarify what the duty of care is. Or perhaps the committee would prefer to recommend to the department that there not be a duty of care, that because it is too complicated, the secretary should not extend these requirements on NAGPRA cultural items prior to repatriation. Similarly, I would say that the department would be very interested if this committee had a recommendation on what museums should be required to do beyond the proposed text here of safeguarding and preserving. So I guess rather than pulling up 36 CFR 79 right now, I would want the committee to have a discussion about whether or not there should be a duty to care for items prior to repatriation and whether that should be a part of these regulations.
Well, I think 36 CFR 79 helps to define that, so it would be good to pull that up for everyone.
I personally and professionally think it would be good to have a duty of care statement. I just have concerns about how that's drafted.
And I'm also in favor of duty of care. I think it's the details that we need to sort of think about, not only the what that is, but how we can pull that in to apply here. Kind of following up on that, and perhaps Frank, or Brady, there's been a lot of discussion by this committee about federal collections that are in non-federal repositories. And I'm not a big expert on 36 CFR 79. For those federal collections that are in non-federal repositories, is there an obligation for the non-federal repository to follow the provisions of 36 CFR 79, at least for the archaeological collections? Does that transfer to them either under contract or however? And I just don't know the answer.
It this is Stephen, it generally transfers under the contract or the agreement between the agency and the repository. Assuming that the agency knows who the repository is, which is another issue that we're trying to address in the draft regulations.
I think that's a huge concern. I think that we do need to grapple with. Yeah,
it is.
Yeah, this is Frank. Some museums readily acknowledge it. Some agencies readily acknowledge it and have explicit agreements for a museum or another non-federal repository to care for their collections, including the agency's NAGPRA responsibilities, because the collection typically, and Brady or Stephen can correct me on this one as well, it doesn't go away when the collection is in another repository, unless there has been some kind of a transfer of responsibilities or a transfer of quote unquote ownership of the collection. But in many cases that hasn't happened. And since the 36 CFR regs went into effect, also actually in I think in 1990, many more agencies have created such agreements, and many more museums as well, because along with that agreement, typically there's a recognition, at least, that the agency should be providing some funding to support the care that the repository is providing.
So in the case of non-federal, thank you, Frank. Yes, that's true. So then in the case of non-federal repositories, the first sentence of the draft regulations would be fulfilled through, for those collections that are still under the control of the federal agency, would be fulfilled through an agreement or other requirements that between the federal agency and the repository.
Mm-hmm. I guess just to sort of close that out, I guess I was in responding to Tim, I wasn't all that clear, I guess, but I don't think the responsibility automatically goes to the repository when say the physical collection is at the repository. I think there has to be something more for if the agency doesn't want to continue to be responsible. And of course, many agencies don't have the funding, so they may feel that way at a management level, but they still have that responsibility, and many of them have recognized it and are at least trying to take steps, and in some cases have taken steps to ensure that the repository receives the support from the agency to carry out these responsibilities that it's carrying out on a day-to-day curatorial basis.
Yes.
Can we talk about a different section, or do we still have more duty of care issues?
I'm curious about public responses to duty of care as well, if those could be put together so that we could review what has been said.
Sorry, Anna, are you asking for the public to provide input to the committee on duty of care, or are you asking for comments the department has already received on this issue?
Well, both sounds good.
Other questions or comments about the paragraphs under 10.1?
I actually wanted to start back with the purpose one, if that's okay. In comparing that with the current purpose, I noticed that the first section in the current regs that outlines sort of the statutory basis of this was stricken. I see no issue with that. That's fine. But I did notice that the current regs say these regulations develop a systematic approach for determining the rights of descendants, Indian tribes, Native Hawaiian organizations. And I noticed that that rights of language was taken out in the current version and replaced with systematic process for the disposition and repatriation. And I guess it's what sort of jarred me actually a little bit was when you started your presentation today, Melanie. I think the first slide had that determining the rights of language.
Mm-hmm.
So I'm kind of interested in why that was taken out and what the effect might be.
Well, I think the committee should discuss the effect. Of that language and its revision here.
Can you explain why it was taken out?
I think in general throughout the regulations, but with this change specifically, there was an effort to clarify and simplify the language and to be more explicit about what the systematic process is. And that's where using disposition and repatriation as the purpose of these regulations was clarifying the purpose.
I mean, it's that particular language, the new language seems very focused on exactly what the regs do. I guess I'm a little concerned and probably would like to hear from Barnaby and Armin and John and Honor in particular on what their feeling about that is.
This is Barnaby. I'm a little confused on what you're referring to. I'm looking at my documents that were submitted for the meeting, and I don't see it anywhere. So I'm not sure what you're talking about. Which language are you talking about?
I think the one that I'm referring to, I think the draft document, the new draft document reads, the regulations provide a systematic process for the disposition and repatriation of Native American human remains and the rest of the items. And the current regulations say the regulations develop a systematic process for determining the rights of lineal descendants, Indian tribes, and Native Hawaiian organizations to Native American human remains, objects, funerary objects, sacred objects, objects of cultural patrimony. So it's that issue of whether this process is about determining rights of lineal descendants, Indian tribes, and Native Hawaiian organizations that I guess I'm seeking your advice on, your opinion on.
So it's just the term right, basically, that I guess the main point of the language, the rights of the tribes.
Yes, it's
And
replacing determining the rights with disposition and repatriation.
Well, it would seem to me that NAGPRA in itself, the legislation, more or less determined the rights of the tribes in order for it to be even legislated. And to me, I don't think it makes any difference with just that one word being absent now in the new draft. That's all I have.
Melanie, this is Armin.
Yes.
Steve, are you still there? Mr. Simpson?
Yes, sir.
Yes, Steve. What is being discussed is the word rights. Can there be
Yes.
another word? Can there be another word or words to replace rights?
There could be. I think I would second what Barnaby just said. Actually, that I think part of the language, part of the reasoning behind this was not only what Melanie said earlier about the second part of this sentence, which talks about the items with which the tribes are affiliated, and that's not quite right. But the other thing is that the regulations are intended to develop the process. They do not determine the rights. As Barnaby noted, the rights are actually determined by the statute. Congress has already done that. So the point of the regulations is to come up with the reason that we took that language out, I think, or at least one of the reasons, was that the point of the regulations is to provide that process. The rights have already been determined by Congress, as Barnaby pointed out. I mean, we can come up with a different, I'm trying to come up with a word for it. I don't know. I could probably try and come up with some language, Armand. I'm not sure I could do it right now, but I mean, if you want that concept still in the regulations, we could come up with some language to do that. If the committee suggests that we still put that in, have that concept in there.
This is Brady. I just want to add to Stephen's point that this change or the clarification as to the purpose of the regulations here doesn't have a legal impact. The goal, like Stephen and Melanie both said, was clarification as to the purpose of the regulations, and Barnaby very aptly pointed out one of the reasons behind that the statute is the source of the rights, not the regulations. That the regulations are trying to help define the process to exercise those rights. and work through in some cases how we allocate them. But the rights exist, and that was an area that we thought could cause confusion as it was placed within the regulations. That was somewhat inconsistent with the intent of the statute. If the committee wants to recommend a change in how we describe the purpose here, perfect. That's perfectly acceptable. And like Stephen said, I think we'd be happy to work with the committee as they're working through recommendations on exactly what language they're thinking of, or at least what the concept is, and then the solicitor's office can be to help define what the wording would affect the concept you're most interested in.
Okay, thank you, Brady. So, how about this, Tim and Frank? If we just take out the word the and rights of. Does that work?
I guess I don't understand. I think that's exactly what the Park Service has taken out of the current regs, and that's the way that it reads in the draft, and it's replaced with a process for the disposition and repatriation. And I am not firmly wedded to either of those, but I just wanted to raise the issue to see if there was concern, particularly of the nominees from Indian tribes.
Chairman Minthorn, this is Honor.
Yes, Honor.
Thank you. I think it's important to mention the rights of lineal descendants, Indian tribes, and Native Hawaiian organizations. And I'm just opening this up for a little bit more discussion. I understand that the regulations mention the purpose of NAGPRA, and it seems that there are references to other laws and regulations throughout this document. Would it be worthwhile to also incorporate treaties, the UN Declaration on the Rights of Indigenous Peoples, and other documentation to further a discussion about the rights of lineal descendants, Indian tribes, and Native Hawaiian organizations, for instance?
So Melanie, this is Armin.
Yes.
So Melanie, so far the discussion, so what do we have on the table that can be considered as far as changes?
Well, the committee could make a recommendation to the department that these regulations incorporate other authorities. I might caution the committee that would go beyond the scope of what is in the Act, and these regulations are limited to the requirements and scope of NAGPRA as it is codified. I think that the comment by honor is related to recognizing many rights of Indian tribes and Native Hawaiian organizations. And I'm not sure how that might fit into the purpose paragraph for what these regulations achieve.
Well, Melanie, again, this is Armin. So, you know, and it's always good that we have legal people to give us advice and help us along with what the committee's authority is and what it isn't. And certainly we cannot exceed or go beyond existing regulations and or laws. And certainly that's a gray area as far as other authorities. So again, we as a committee have a frame that we have to stay within, and we cannot exceed that. And this is, again, key where our legal people that work with Interior need to be looked to, so that not only are we within legal perimeters, but whenever we suggest to go outside of those perimeters, then we need to hear from the legal people so that we don't, as a committee, get ourselves in trouble in exceeding the purview that this committee has. So just that as a comment, Melanie. Thank you.
And thank you, Armand. This is Stephen. The reference that Melanie was making to the act is section 13 of NAGPRA, which says that the secretary shall promulgate regulations to carry out this act. Thus, the regulations are limited to carrying out NAGPRA. They are not intended, and we would get no deference from any court if we decided to try and carry out some other statute. The references to other statutes in these regulations are because, especially ARPA, are because in the relevant sections of NAGPRA refer to ARPA in that context, or to if NAGPRA refers to another statute, we can refer to that as well. But the intent of these regulations is to carry out what Congress told the Secretary to do, which is to promulgate regulations carrying out NAGPRA.
Thank you, Stephen. If I could just, related to the purpose of NAGPRA, if I could just provide a little bit of a recent experience that I had. In March, I gave a presentation to the NAGPRA Community of Practice on cultural affiliation. And in that presentation, I referenced the purpose of NAGPRA, both from the statute as, in that case, the congressional reports on NAGPRA, which gave a stated purpose of the law, and then the current regulation text on the purpose of NAGPRA. And I think that there is an important issue that needs to be addressed in the purpose section of these regulations, and that is that the purpose of NAGPRA is repatriation, the return of Native American human remains and other items, or the disposition from federal lands of those items in accordance with the law. During that discussion on that presentation, there was other points of view about the purpose of NAGPRA including the purpose of NAGPRA being a balance of interests between science and tribes. And I think that in clarifying the purpose of the regulations in this instance, it's an opportunity to make clear what the purpose of this process is.
Okay, any other comments or questions from the committee?
This is Barnaby. I don't have any comments. Thank you.
Okay, Melanie, moving on.
So again, under the introduction section, there has been a removal of a paragraph currently under applicability. In addition, the third paragraph under applicability in the current regulations has been the first sentence at least has been removed, and the language about final determinations and final agency action has been moved to a separate paragraph in the introduction. As I mentioned in my overview, there are three new paragraphs: duty of care, which we've already discussed, delivery of written documents, and deadlines and timelines. In the rest of the introduction section is information that currently is in parts of 1015 and 1017 in the current regulations, but has been moved to this general introduction section at the beginning, with some clarification on certainly on the failure to make a claim or request. Tim?
Yes, Tim?
On 10.1B, the section that is being removed is 10.1B2, and I fully endorse removing that section. I think it's inartfully drafted, and I have no problem with that at all. I do have a concern about 10.1 or 10.1B1, and that's the elimination of possession or control. That phrase is used repeatedly throughout the statute, particularly as it applies to the requirement for museum and federal agencies to conduct inventories, summaries, the inventory of culturally unidentifiable human remains, and distinguishing between associated and unassociated funerary objects. Back in the day when we were writing this, we viewed possession and control as a Venn diagram of two partially overlapping pieces or circles that most institutions, most museums, most federal agencies had both possession and control of their collections. They had it on the shelf and they controlled it, so they were able to make decisions regarding repatriation. The parts of the circles that went outside, there were some institutions that had control of collections, but they didn't have possession of them. And much of that portion of collections were collections originating from federal land that the United States retained control of, but that it was in a non-federal repository. So it was in the possession of another institution. And then on the other
I'm
side,
sorry, Tim, if I can just interrupt you for a minute. That's a common misunderstanding of possession as it's currently defined in the regulations. And that is a museum that has physical custody of an item but does not have control, does not have possession under the way that possession is defined. Under the current regulations definition of possession, physical custody and control are both required to have possession. And this is why possession has been removed from the regulations entirely.
thanks for that clarification. Oops, wait a minute. Thanks for that explanation. What I'm telling you is what we meant when we drafted that and how we interpreted the statute. So the Venn diagram, the majority you had both possession and control. There were some where control was held by one entity, often the federal government, and possession was with another institution. And then
But again, I need to stop you there because that's not possession. Possession requires control. The way that the term is defined in the regulations, it requires possession requires control. So you cannot have possession if you do not have control of an item. And if you want to, let me scroll down to the definition. I had prepared this in a slide on definitions because this is a significant issue that we continually have confusion over. And the current text says that possession means having physical custody of an object with a sufficient legal interest to lawfully treat the object as part of its collection. And it's a sufficient legal interest to lawfully treat the object is the definition of control. So possession requires control under the current regulatory text.
I certainly don't read it that way. I think that is a much more general statement. And it's not about, I think the definition of control that you have proposed, which the revised definition of control, I don't think I have any issue with. I think it is much more precise than the one that is in the current regulations. So I do see the definition of control in the new one as much better. The definition of possession, it's sufficient legal authority to lawfully treat the object as part of its collection. That's unrelated to issues related or regarding repatriation proper. And there are various gradients of where that line goes. There's the whole issue of lapsed loans. There's all kinds of things that a museum will have physical custody of something, and what that level of control is in terms of making decisions regarding its care are all over the board. And that's why this language is somewhat imprecise. That was suggested by our legal advisor at the time, Lars Hanslin, to sort of deal with this in a general sort of way. But I see that the way custody is being dealt with in the new reg sort of cuts out some of these objects that would be in the possession, in the physical custody of an institution, but don't meet the definition of control as you are redefining it. So it basically takes some of these objects that normally would be considered under NAGPRA and takes them out. And I think that that's problematic. I think that that's a disservice to the tribes.
I want to clarify that the effect you just described isn't entirely accurate. The issue of control, I think it is the core one here, where it's not so much defining defining which items are subject to NAGPRA as opposed to which entity has control and the responsibility to fulfill duties under NAGPRA, which is one of the biggest areas of confusion that arise currently with the use of the term possession to mean something other than what people commonly think possession means, right? Someone assumes possession is simply custody, and that's not how the regulations currently define it, which is one of the roots of the confusion. How we currently define items under NAGPRA and who has control of them isn't changing as part of this revision. It's just being clarified so there isn't so much confusion about what possession means, because at present the core issue is control, and under the revision it'll clarify by using that term exclusively that control is the determining factor for assessing the NAGPRA responsibilities of a federal agency or a museum.
Thanks, Brady. Let me just put it straight. I am in no way defending the current regulatory definitions of possession and control. These were drafted by our legal advisor at the time, who saw a need to put something in there. And if we revise all of those to be more effective, I'm all for it. However, I do think we need to take a step back and realize that Congress said that this applied to all objects in the possession or control of a federal agency or a museum. So that language, that general language that is not defined in the statute, and thus the common meaning of the term applies, is sort of where we need to start from, not from the regulatory text, which I think is flawed, but I think we need to take a step back at possession and control as used in the statute.
This is Frank. I'm trying to follow this distinction. Tim, are you suggesting that instead of the word custody, that the word possession be used, but the meaning is as described in the new draft?
Part of it, I think I would be happy to use possession instead of control because it's a statutory term. And to replace possession in this sentence that we're focusing on here. But I think I'm willing to put that discussion off when we get to the custody definition to see if that meets my concerns. I just wanted to highlight it here that the statute consistently uses possession or control throughout. And I'm nervous about stepping away from that. And I realize that the current regulation, I don't think certainly doesn't capture the common meaning of those terms, which is what we have to start with as undefined terms that Congress put in there. So I don't want to get rid of the word possession because it's a statutory term. How we define it, I think we're all smart people. We can think this through and come up with a good one, and whether custody as currently used in or currently proposed in this draft meets those needs or not, I think I'm willing to delay that until we get to that part. But I just wanted to point out, dropping it out entirely is problematic because Congress clearly meant for museums and federal agencies to be responsible for repatriation of cultural items in their possession, whatever that means. So eliminating it, I think, definitely goes counter to congressional intent. How we define it to be a workable term is another matter.
Well, I would highlight possession and control as a major obstacle to repatriation. The reality is that 30 years later, many museums are still trying to sort out who has control of their collections, whether they have control, legal interest, and are able to repatriate, or if there is some other entity that has control. And the attempt here was to simplify the terms so that it would force museums and federal agencies to do what Congress intended, which is to determine who has control so that repatriation can occur.
And I guess from my perspective, I understand that. It has been problematic. I think you can understand why the definitions of possession and control in the current regulations are somewhat convoluted, because we were told by legal counsel back in the day that if Congress said this applies to objects in the possession or control of museums and federal agencies, that's what we were stuck with. So we had to make it work. So one way is to come up with with regulatory language to define them in a way that works. But I think the approach that is proposed here, and again, I will defer to a discussion on what custody means later, but I do think it's important to retain that word because it's the word that Congress gave us.
The department in preparing this draft text has said that it's sufficient to use control, legally sufficient to use control, and to not use possession. If you have concerns though about dropping that term outside of what the attorneys might advise, then that would be important for the committee to discuss, where this change might cause an issue in achieving the purposes of NAGPRA. I think, though, it's important that the committee the committee focus on providing recommendations to the department about what might be lost in getting rid of the term possession in this case, rather than whether it's legally sufficient or not. Brady, I said the word legally a lot, so you popped up.
Yes, you did. This has come up now a couple of times today, and I want to make I guess 2 points to the committee now. First is that the draft text that has been made public and is out for tribes to review for consultation and before the committee has been reviewed by the solicitor's office for legal sufficiency. So to the extent there are questions about its sufficiency, I want to assure you all that it has had a legal review. Second, I would echo a bit of what Melanie just said to encourage the committee to make use of its own authority and its own purposes in the direction that Melanie has given to provide feedback on what the impacts of these changes could be, as opposed to questioning the sufficiency thereunder. Examining legal sufficiency is not a responsibility of this committee. And it's not even a responsibility of the National NAGPRA program. And I would just like to say the solicitor's office has your back on those points. So if there are impacts that you see arising from these changes, that is squarely a responsibility of the committee to address and provide recommendation back to the secretary on how such a change could have a practical impact, could have a real impact that affects museums or that affects tribes. As to the nuances of whether an item is legally sufficient, the solicitor's office will continue to review drafts as they go forward and continue to consider the legal sufficiency of any changes that might be considered, even ones in response to recommendations from the committee. So I would discourage you from spending too much time trying to do a lawyer's job, because it's not fun and might not be the most productive use of the committee's time.
Melanie, this is Armin. We need to let the lawyers do what they do best. Committee, we can't be lawyers. And the discussion that we've had so far, we've gotten off course. So we need to get back on course and talk and make some progress on the draft regulations. Whether we want them to stay the same or we want what's being suggested. But again, that's what lawyers do. And they can protect the interest of the committee. And we need to depend on those people. So again, the solicitor's office, they'll do what they do. And in the interest of the committee, in the interest of NAGPRA, that's what will be upheld. So we don't want to go into an area that is out of purview of the committee and NAGPRA. We don't want to do that. So we need to get back on track and continue our discussion on these draft regulations. Thank you.
I'm going to suggest that since we have already begun a bit of a discussion around the definitions, that we continue to that end. And in this case, I took the discussion of the review committee at your last meeting specifically about the definitions and created an additional document that I shared with the committee this afternoon and posted to the regulations webpage as well. So anybody can find it. And it's basically an index to the draft text definitions. And what it does is in 2 tables sets up either by the current definitions in the current regulations or in the draft regulations. So the 2 tables are sorted in a different way and makes a comparison between them. So you can then do directly what we have been discussing here on the screen. It's a little difficult to do that given that the current regulations are organized thematically and the draft regulations are organized alphabetically. So I was hopeful that this would assist the committee as well as members of the public in looking at the definitions in the current regulations and in the draft text. Again, you can find that on the regulations webpage, an index to the draft text definitions. Just to highlight the definitions that have been removed, one we've already discussed. The possession has been removed. Likewise, the definition for the various officials has been removed. And instead, the subject of the regulations is the federal agency, museum, or Indian tribe itself, as opposed to having a secondary definition of the official. The definition of Native Hawaiian has been incorporated into the definition of a Native Hawaiian organization rather than being a separate definition. And then lastly, as has been discussed before, these regulations remove the term culturally unidentifiable. In addition, there is a list of new definitions that have been added, highlighting one concern of this committee. Consultation has been defined in the regulations. Cultural items has been defined in these regulations, in the draft regulations, as well as other terms that are useful in crafting the language of the regulations. I will again point to a new definition of geographic affiliation, or geographically affiliated, which has been added to the definitions, although the process and procedure for items that have a geographic affiliation is the same as the current process for those culturally unidentifiable human remains under 10.11. So in that case, the term has been changed, but the process for the repatriation of those items remains Aboriginal land. I highlighted a couple of definitions that I thought the committee should be aware of. One of those we've already discussed, which is the change of possession and control to just control. The other definitions that I think is important for the committee to be aware of is currently under the definitions, there's a definition for disposition, and disposition covers a number of different terms that we commonly use. So under the current regulations, disposition means transfer of control of items to include repatriation. So any of the ways that an object might be transferred or human remains might be transferred under the regulations means disposition. Instead, in the draft text, there are two separate definitions that apply in the two separate subparts. Disposition means acknowledgement of control of items from federal or tribal land. So disposition then is only used under section subpart B of the draft regulations. Repatriation means conveying control of a cultural item in a holding or collection. So repatriation then is the only term that's used in subpart C for conveying control of holdings or collections. I wanted to highlight those two items or that definition section for the committee. Again, the attempt here is to clarify and distinguish between the process under subpart B and subpart C. As I already showed you and as we already discussed, there is a current definition of possession and a definition for control, and the current draft only uses the term control and then defines a term custody to cover those items that are not under the control, but maybe in the physical custody of institution. So that is everything I prepared for you on the definitions. Again, I highly recommend that both the committee and the public take a closer look at the two tables that I've prepared to see how the definitions have been, how to compare the definitions.
Committee, questions or comments?
This is Frank. I have a couple of questions, I think. Melanie, could you put up the list of new definitions that you just had? I have questions about why there's a need to include and define at least the first three terms. Iahupa, ARPA Indian lands and in ARPA public lands.
Sure. So the first definition is used, that term is used in determining the closest culturally affiliated Native Hawaiian organization. You can find that in the draft text at
I have it in the draft text. I saw it there. It's on page 4, top of page 4.
Oh, I'm sorry. Within the text of the regulations, you can find it under 10.3D.
Oh, okay. Okay.
It's a category of Native Hawaiian organization that allows for a better priority order when there are multiple culturally affiliated Native Hawaiian organizations. The other two, the ARPA definitions of Indian lands and public lands, are used to further clarify the distinction under NAGPRA of tribal land, because there is a difference in how NAGPRA defines tribal land and how ARPA defines Indian lands and public lands. Those terms are used in Subpart B. I'm not able to find it right away, but it's there somewhere in the regulatory text to distinguish between those different kinds of land.
And they're different. If you're saying they're different in ARPA than they are in NAGPRA, is that
That's
in the
correct.
statutes themselves?
Yes. Mm-hmm.
Thank you.
Mr. Chair?
Yes, Tim.
I'm sorry to do this. I actually had one more point to discuss on 10.1.
Okay.
Under 10.1G, there's a reference under judicial jurisdiction. The United States District Court has jurisdiction over any action by any person alleging a violation of the act or this part. And that's a pretty close paraphrase of statutory language. And I guess I was interested in hearing from Brady or Stephen on why the need to put that statutory reference in the regs.
Stephen, are you
Tim,
there?
give us a second to pull up the.
Yeah, we put it in
Pull it up.
the reg. Tim, if you look at the difference between this language and the statute, the main difference is "or this part." And so we thought that we needed to, we would go ahead and put it in the regulation to make sure that part was covered. And as Melanie just pointed out, it points out here, it is that same or similar language is already in the current regulations at 10.17A that she has on her screen.
Thanks, Stephen.
You're welcome.
Thank you, Stephen.
I guess the one thing that I would like to point out is that particular reference to 25 U.S.C. 3013 is not the only place where judicial jurisdiction is defined in the statute. And I think it may make this regulatory reference a little fuller if we also included text afterwards that says something to the effect of the United States Court of Federal Claims has jurisdiction to determine if, quote, right of possession, unquote, as applied in the Act, would result in a Fifth Amendment taking by the United States. That's also statutory language, and I think it's a good pairing with this piece that we're putting here.
If the committee would like to recommend that, that's fine.
What are the wishes of the committee?
This is Barnaby. Would you repeat that, Tim, what you're recommending?
Give me a second. There's a separate place in the statute. The current definition or the current language under judicial jurisdiction, the United States District Court has jurisdiction over any action by any person alleging a violation of the Act or this part, is a very close paraphrase of the statutory language, and I think that's perfectly appropriate. But I did want to point out that the statute itself establishes another set of judicial jurisdiction for a particular narrow focus, and that would read something to the effect of the United States Courts of Federal Claims has jurisdiction to determine if, quote, right of possession, unquote, as applied in the Act would result in a Fifth Amendment taking by the United States. And I tried to keep that language very close to what the statute said, but I would propose to include that second direction on that particular issue to a different court. It's not the district courts. The Court of Federal Claims is a different administrative structure. It's a different type of federal court.
One point of clarification, and this is just for the committee's knowledge, not a comment on this as a recommendation. Tim, the section you're referring to, the reference to the Court of Federal Claims, is trying to address the remedy for a potential violation of a right that exists outside of NAGPRA. It'd be a constitutional claim, and I think that's the reason this hasn't traditionally been addressed within the regulations, which are trying to address rights specific to NAGPRA. That said, clarifying it in the regulations, there could be good policy or maybe even legal reasons to do it. But I just wanted to make sure it was clear that there's a distinction, right? NAGPRA isn't creating these rights that would have to be adjudicated in the Court of Federal Claims. That the Constitution created them, and Congress specifically wanted to flag them, in particular regarding summary objects, in case it ran into an issue there, even though Congress wasn't sure if there would be an issue there, but to kind of cover itself, it mentions that point. So I hope that distinction is helpful. Just that I guess the exception to the rule of going to the district court is because of rights that exist outside of NAGPRA, and thus we're not providing guidance or direction on those generally. But the committee could certainly recommend to provide a little clarity there.
Much appreciated, Brady. From my experience, 10 years of experience doing litigation support with the Office of the Secretary and the Office of Special Trustee, I do know that those are two very different courts and they behave in very different ways. So thanks.
Hey, committee, anything else? Okay, Melanie, moving on.
I wanted to be sure the committee appreciated the changes that have been made under what is currently at 1014. for lineal descent and cultural affiliation, and is now in 10.3 for cultural affiliation. Again, in the presentation, I have put some comparative text for the committee to review. Cultural affiliation, as I think the committee is aware, is one of the issues that continually a barrier to repatriation. And in some ways, the regulatory language in the current form has been interpreted as limiting factors on on finding cultural affiliation. So the intent of section 10.3 of the draft is to clarify cultural affiliation based on the language in the congressional reports on NAGPRA. Specifically, the congressional reports talk about establishing a connection that cultural affiliation, while it's defined as a shared group identity, is really about establishing a connection between an Indian tribe and a cultural item. And so that language has been brought into the draft text. Here is a comparison of what are essentially the three elements of cultural affiliation. In the current regulations at 10.14, the language is all of the following requirements must be met. Existence of the identifiable present day, evidence of the existence of an earlier group, and evidence of the existence of a shared group identity. This has been simplified in the draft text to say that cultural affiliation is established by identifying 1, 2, and 3. And in the draft text, cultural affiliation is defined or encompasses language here that makes it clear that cultural affiliation can be established with one or more earlier groups, as well as one or more present-day Indian tribes, and that the relationship of shared group identity is between the earlier groups and the present-day Indian tribes. One of the most perceived limitations on cultural affiliation is in the current regulations in the discussion of what is an identifiable earlier group. The language in the current regulation provides some specific evidence sufficient to establish an earlier group, and you can see that here on the top half. That has been significantly reduced in the current draft text to say that an identifiable earlier group, the requirement is information to identify that earlier group, and that it can include, but it's not limited to, information sufficient to establish the identity or cultural characteristics. Again, an attempt to simplify the regulatory language to make the process clearer for museums and Indian tribes. In terms of the relationship of shared group identity, the current regulations require evidence of the existence of a shared group identity and then elaborates on what that evidence might be. In the draft text, it talks about establishing a relationship of shared group identity, and that shared group identity may come in various forms. An earlier group may have a relationship to more than one Indian tribe, as well as multiple earlier groups may be connected to a cultural item, and as a result, a relationship may exist to Indian tribes that do not themselves have a cultural, a shared group identity. So again, it's an attempt to clarify the requirements for cultural affiliation, to simplify the language used in the regulatory text about cultural affiliation. Finally, there's some changes in the language related to the standard of proof and a finding of cultural affiliation. In general, both of these are echoes of what is in the text of the law as well as in the congressional record, but they have been combined and simplified in the draft text to be clearer on what is required for establishing cultural affiliation. Are there pieces of 10.3 that you would like to discuss?
Hi, Melanie. This is Honor, and hello, Chair Jorn. I think what I'd like to do is go back to section 10.2 and put them up against each other, the draft and the current regs, so that we can complete going through that. And I'd just like to make a recommendation to the committee, given our time, that we also, I'm not sure that we're actually going to get through everything today, but I think it's really important to hear any public comments as well in the sections that we have gone through. So it'd be important to make time for that.
Again, it's very difficult to do a side-by-side comparison of the definitions in 10.2. It's because of the way that they are organized, you can't easily put them on the screen at the same time, but that's what I have attempted to do with these tables, is provide you with a means of indexing that the definitions. But I can certainly scroll through the definitions and try to match them up as best I can on the screen.
Thanks, Melanie. And I think that document was only just recently sent to us, so it will take a little time for the committee to go through. But I appreciate that you sent it. Thank you.
So if you look at second table, you'll see that the definition for the act is somewhat similar, although yeah, it's the act means the Native American Graves Protection and Repatriation Act is verbatim, just formatted slightly differently.
Melanie, I'd like to have a little discussion, hopefully with the committee, about the terminology between acknowledged Aboriginal land, dedicated Aboriginal land, maybe just starting first with what your thoughts were, or the department's thoughts were in creating that, and then opening it up to the broader committee.
Sure. So under the current regulations, there are two uses of Aboriginal land that vary. In Subpart B, on federal or tribal lands, Aboriginal land is limited to land identified in final judgments of the Indian Claims Commission or Court of Claims. And that is a type of Aboriginal land. That definition is carried forward under 10.11 of the current regs as one way of finding Aboriginal land. So the goal here was to create two separate terms for Aboriginal land that clarified that distinction between Aboriginal land adjudicated under a final judgment of the Indian Claims Commission or the Court of Claims, as opposed to acknowledged Aboriginal land, which incorporates the definition under 10.11 and includes treaties, acts of Congress, or executive orders as means of identifying Aboriginal occupation. So it is, that's the effort here was to clarify those two terms. And as I pull up here, there are, the definitions are similar to what is in the current regulatory text in 10.6 and 10.11, but has been moved to the definitions section of the draft text. Tim?
Just for clarification, is it correct to assume that adjudicated Aboriginal lands is somewhat narrower in its sort of application than acknowledged Aboriginal land, primarily because the basis for the adjudicated Aboriginal lands comes from Section 3 of the statute. So it's harder to broaden that out, whereas acknowledged Aboriginal lands comes from recommendations made by this review committee over a series of drafts and finalized in their recommendations on the disposition of culturally unidentifiable human remains. So it's not statutorily driven. There's more flexibility in how that can be crafted. Is that fair?
Yes, the problem is the current regulations refer to both kinds of Aboriginal land only as Aboriginal land. And so the effort here was to take that same distinction and to define Aboriginal land in two ways, so that adjudicated Aboriginal land can apply to Subpart B as well as Subpart C, and acknowledged Aboriginal land only applies in Subpart C.
I thoroughly approve of the concept of distinguishing these and of the content of the language. In particular, on adjudicated Aboriginal land, I did want to ask whether the particular final judgment or judgment concerning a settlement, as long as that judgment or settlement is explicitly recognized. My recollection is that acknowledgement of settlements, particularly under the Indian Claims Commission, comes from the Organic Act for the Indian Claims Commission. Is that fair?
It actually doesn't much. The language from the Indian Claims Commission Act is not as clear as it may have been thought, and so this language is actually drawn or based on an examination of excuse me, of the various cases and settlements that the Claims Commission had authorized, and how all of that worked in the Indian Claims Commission case law.
And the solicitor's office has obviously signed off on this, so.
I did the examination and came up with this language, Tim.
Yeah, very artfully done.
Thank you.
On acknowledged Aboriginal land, under 1, the treaty sent by the President to the United States Senate for ratification. Did you come up with that too?
I think we probably did in jointly. When Brady said that this regulation has undergone legal review, he was being well, he said it was undergone legal review. What actually happened was that either Brady and I or Carla Maddox and I were in the room and working on it all of the time with National NAGPRA staff. So the language here is a distillation of, I think, of advice that we have been giving since the promulgation of 1011, and how we have considered that the language in 1011 to play out. The authoritative governmental documents language that is in 1011 has played out. So the point here, the point of that particular provision is not because the treaty, the reason we are looking at these documents or suggesting that these documents be looked at by a museum or a federal agency is not, especially in the case of the treaties, is not for treaty rights. Is not whether it doesn't talk weird. We're not looking at it for the validity of the treaty, because of course a treaty is only valid if it has been ratified by the Senate. However, the government, what we are looking for here is where the government thinks the tribes were and where the government acknowledges that the tribes were. And so the president negotiating a treaty and sending and at the point that it is sent to the Senate for ratification is the president's acknowledgement that that's where the tribe was. And so that's why we went back to that point, because there are draft treaties out there that were never ratified by the Senate, yet they are still useful for tribes or for museums and federal agencies for figuring out where tribes were.
Yeah, very nicely done.
Thank you.
Could
I just follow up for a second, Tim, on that question, because I noticed that also, and I'm just wondering about how you determine historical accuracy in any of these cases, in terms of this using that kind of a standard in terms of information.
It is the language of the document speaks for itself.
Well,
so if there is an act of Congress that says, this is where this tribe was, then that act of Congress says that. If there is a draft treaty that the president gave to Congress to ratify that says that, then that's what the treaty says. So we're going based on the language of the document.
I didn't mean to interrupt. I just wanted to get it.
Oh, sorry. That's where we're headed, Frank. Does that help?
A little bit. Yep.
Okay.
Thank you.
Mm-hmm.
The Tim had some more to say, I think.
I guess it's just a follow-up question. I'm sure you've, I don't think you've probably put a kind of a regulatory impact assessment forward, but that particular provision, do you have any idea how many treaties might fall under that are not ratified? Sorry.
No, I don't.
Will that be included in the regulatory impact assessment? Because I think there will be people that are interested in where that applies.
I'm not sure what you mean by the regulatory impact statement. We provide a economic impact analysis. Is that what you're referring to?
I think my recollection is that there was a general document that we would usually put forward to the department and maybe to OMB. Do you remember, Frank? That sort of outlined, we're going to change this. Here's what we think that'll do.
It may, in fact, have been the economic analysis that Melanie is referring to. I don't recall specifically, but there were such documents that we did have to complete as we put the regulations forward. There's a paperwork one for sure.
Yeah. Anyway, good job, guys.
Melanie, I have a question about this one, if I may, given that, particularly given this discussion just now. So you said, I think you said something like the acknowledged Aboriginal land and the adjudicated Aboriginal land criteria for making a determination for repatriation or disposition, whichever the right term is, were similar. That this new language in the definitions was similar to what is in 10.11 currently.
Mm-hmm.
But it also sounded from the discussion that Tim and Stephen just had that the first one, number one, so 10.21, or no, I'm sorry, under acknowledge Aboriginal land, that the subpart 1 is new. And so how does the rest of this line up in terms of adding to the information that one would look at?
So this information is generally the 1 through 5 here of acknowledged Aboriginal land is included in the preamble to the 1011 rule, in particular the language here about a treaty between a foreign or colonial government. The regulatory language right now just says a treaty. It doesn't explain whether that's required a ratification by the Senate of the treaty or if it could be just a treaty sent by the president. So the effort here was to clarify the existing regulatory language where we have been informed that it is problematic or confusing for museums in how to apply the existing regulatory language. So here is the existing language in 10.11 of Aboriginal occupation is defined here. This is one of the 2 places. So there is additional information in the preamble to 1011 that talks about treaties with foreign or colonial governments, as well as other authoritative sources, but that language is not included in the regulatory text. So the effort here under acknowledged Aboriginal land was to bring all of that information into the regulatory definition for acknowledged Aboriginal land.
I'm not familiar with the preamble to 10.11 either, but that something is mentioned in the preamble doesn't necessarily mean that it's, in fact, it wasn't included in the regulation for some reason. So I'm just wondering if this is how much of a broadening this is in terms of the kind of information or where the information comes from in making some of these determinations about Aboriginal lands, because we all know that I think that in the original act that the Congress was careful in identifying the U.S. Court of Claims and the Indian Claims Commission, where there had been a review and quite a historical review of some of that data, and so they stuck to those as important standards for evaluating what information was available and given where NAGPRA items were found or removed from or excavated from.
Yes, the expansion of Aboriginal land beyond adjudicated Aboriginal land comes from the recommendations of the Review Committee on a process for culturally unidentifiable human remains. And that is where the language that's in the current regulatory text about treaties, acts of Congress, or executive orders comes from the recommendations of the Review Committee. There is no statutory authority or statutory designation of how how culturally unidentifiable human remains or those that are not culturally affiliated should be assessed. That was Congress asked the review committee to take on that effort, and the 1011 is the result, and the explanation here of those sources of information are based on 10 years of experience with applying this language from 1011.
Thank you.
I have opened the meeting chat. If anyone would like to make public comment, you can put your name into the meeting chat.
If I can make a further comment, we've left the discussion of cultural affiliation and determining cultural affiliation. I would like the opportunity to look at that more carefully and actually give a lot of other people the opportunity to take a look at that, what's been proposed or what's in the draft more carefully as well. One thing I don't think I heard or saw in the flashes of the text that we saw on the screen was an effort or a suggestion as to what shared group identity means. And one thing that troubled me, at least it troubles me now, maybe I'll get over this, is the dropping of the listing of different kinds of evidence that should be looked at, can be used. Again, it's not definitive, but the different kind of evidence that can and should be looked at regarding trying to reach a determination of cultural affiliation. That's gone now, and there's only a reference to consultation information.
There's still here on A is the information for cultural affiliation, which provides the list of sources from the statute.
Oh, okay. You didn't, I thought when you were showing us the text, I didn't see anything like that.
I focused on the changes in the criteria for cultural affiliation because those are changes. I didn't focus on this where there is no change. It is just a reformatting of what's in the existing regulations and in the statute.
Okay. All right. Thanks. Thanks for pointing that out. I didn't pick that up when you were doing your presentation.
To your point, there is not an explanation necessarily in the regulations and the draft text of what is a shared group identity, other than the explanation that there may be multiple earlier groups or multiple relationships of shared group identity.
Well, I think it's been a term that we've struggled to come up with a good, as objective an approach to that as possible. So I didn't see something like that in what you were showing us. So we're still left with that term and trying to figure out exactly what it means in a case-by-case situation.
Well, I will say that that's where we have added the language directly from the congressional reports on cultural affiliation. And it's the purpose Congress intended was to ensure a connection between a cultural item and a present day group that we think clarifies what determining cultural affiliation, what the goal of cultural affiliation is, that it is a connection with that's been included as well in the definition for cultural affiliation in the draft text. The hope is that by including that congressional report language, it will clarify what the goal of a shared group identity is.
Well, it may do so. That would be encouraging if it did, and particularly if all the different connections through the different sorts of information that you've continued to include in the list of types of evidence is looked at carefully.
Chair, this is Honor.
Yes, Honor.
I know that we only have a few minutes left, and I was hopeful we could also hear some of the public comments before the conclusion of this meeting.
Melanie, on that same note, we do have about 10 minutes left, so we need to begin to wrap up.
Yes, sir. So we do have two comments in the chat. I'd like to, if it's okay, I'll call on Barbara Heller first, who wanted to make a comment about duty of care. Just a minute, Barbara, while I allow your mic and camera.
Okay, so my comment about duty of care, I'm an art conservator. So I'm talking about, and the comment said the definition was to safeguard, preserve all cultural items under its control. So I belong to the American Institute of Conservation for Historic and Artistic Objects. We also are called Heritage Preservation. When we talk about long-term care and preservation, we're talking about preventive conservation, not treatment related. It's protecting the objects from damage. So it's due to environmental conditions. So it could be relative humidity, temperature, light, proper storage, improper handling. So I think that's really what the definition is. It's not, treating the objects per se for any kind of restoration, conservation, preservation, but it's ensuring that they are provided the appropriate storage until as needed while they're under their quote unquote care. Is there any questions?
Thank you, Barbara.
Thank you, Barbara. There is another comment in the chat from Cassandra Atencio. Ms. Atencio, if you want to speak to the committee, I could allow that, or I can read your comment. Her comment is, I'm sorry. Her comment is, museums may sometimes only utilize the Indian Court of Claims to find tribes affiliated to an area to say that there are no tribes, and that leaves out tribes whose oral histories, who have oral histories which place them in the area.
Hi, can you hear me?
Yes, we can.
Okay. So that was in reference to the earlier reference about the adjudicated Aboriginal land and the acknowledged Aboriginal lands, which I think is a good idea. And I say that because sometimes a museum or a university or a place will only federal agency that stalls up the matter when it comes to tribal consultation about what they're looking at as when they take place a priority over cultural affiliation. I would, so that's what that comment meant. The other thing I'd like to point out is that about duty of care, to Miss Barbara and to everybody else's comment, is that I think that there should be insertion of through tribal consultation that that duty of a care about how they're caring for the object. Yes, I understand that climate for that object as a tribe, we know that that needs to be considered, but some objects through that tribal perspective are living things, and there are certain things that needs to happen with them. And so I think that's a part of that definition pertaining to duty of care. Thank you.
Thank you. I will note that in the chat, Barbara Heller said she agreed with Cassandra's last statement on consultation regarding traditional care. I don't see any other requests at this time. Here's a comment. Are there changes to the regulations that address or clarify the applicability of NAGPRA to cities, counties, or boroughs that receive federal funds? If not, is it possible to address this to increase the applicability to them in the regulations? I think what the comment here is related to is the definition of museum under NAGPRA, which has two parts. The first part being control of Native American cultural items. The second part is having received federal funds. There is in the draft text some additional clarification of what receives federal funds means beyond just the statutory definition. That may be of use in clarifying the applicability of NAGPRA to various governments or agencies.
Thank you, Melanie. All right, moving on.
We have just about 5 minutes left in our meeting. It looks like Cassandra has raised her hand again. I'm not sure if that was from before or a new one.
It's a new one. Mr. Chair and Ms. Smith. I had a question about purpose, the very first one, about when we were talking about rights omitted, and about how it's already in the statute already. But what about putting not the rights, but the disposition, repatriation, blah blah blah, and at the end put to lineal descendants, Indian tribes, and Native Hawaiian organizations. I know it relates to NAGPRA, but who are you dispositioning and repatriating to? You know, I mean, so that way it's clear that you're dispositioning and repatriating those human remains to Indian tribes or lineal descendants, Indian tribes, and NHOs, even though it's already stated in the statute. That's my comment. Thank you.
Thank you. So, committee, at this point, we have a break in your meeting schedule until August 10th. It's just about 2 weeks. I realize that there's been a lot of information that I have shared with you and the public over the last couple of weeks since the department issued the draft text. I would appreciate any input on additional material or documents that might assist the committee, keeping in mind the limitations of my own staff and timing to produce additional documents at this stage in a quick fashion. I will tell you that I did my best to get you the presentation today as early as possible, and that 2 hours before was as early as possible. There is, as you all are aware, lots of other work for the National NAGPRA program outside of these meetings and the material for the review of the regulations. So I would appreciate input on what would be most useful so I can prioritize my time.
Melanie, this is Armin. What was presented today and all the pieces of the puzzle coming together has been very useful. And I thank you, Melanie, you and all of your coworkers, and try to remind myself as well that your staff are limited and there's only so much that they can do. So we don't want to burden them and overload what they're already doing. So I'll remind myself of that. So thank you, Melanie.
This is Frank. Thanks, Melanie, as well for the documents you sent us already. I didn't get a chance to even open the 3 that came this afternoon, but we'll look forward to looking at them, and perhaps that might give me some ideas, at least, if there's additional information. We did talk about additional contextual information on how this particular draft that we're looking at now came into existence, and I agree with the others. I think Tim and Honor both said that would be helpful, and I just add my voice to that as well. So if you can provide us with a little more, well, if you can provide it with as much in detail as you got, that would, I think, be helpful. Thanks. But thanks to you and for all the others in your attention to this. And I am pleased that we are talking about it. I may not have sounded that way at occasion today, but it's important for this committee to look at the text and consider it and try to make recommendations on things that might make it even more effective. Thank you, and thanks to all my fellow members and attendees.
Hey, Melanie, it's 3 o'clock. Honor, can we have a motion to adjourn?
Sure. Motion to adjourn.
For a second.
Thank you, Chair.
Second.
We're adjourned, Melanie. Thank you.
Thank you all very much.
Thank you, everyone.
Thanks, everybody. Good to see you, even on video. Try to relax during the next 2 weeks.